Welcome. We are ready to begin the UAW-FCA-Ford-General Motors Legal Services webinar, Helpful Hints for Buying and Selling Your Home. Before we begin, I would like to tell you about an upcoming webinar we have planned. We are planning a webinar on QDROs, Qualified Domestic Relations Order, in March. QDRO is actually a court order to divide your pension and 401k after a divorce. Please look for additional information on this webinar in coming weeks. If there's a topic you would like to have covered in a webinar, please let us know. At the end of this webinar, there will be a survey. Please take the time to complete this survey. Okay, now today, we will be talking about buying and selling your real estate. We received a number of questions from you, and we hope through this webinar, we will be able to answer these questions. We will begin with an introduction of ourselves.
Linda Carr is a graduate of the University of Michigan and obtained her law degree from Wayne State University Law School. Linda was an estate and gift tax attorney with the IRS and a judicial attorney for a Wayne County Circuit Court judge prior to joining the former Legal Services Plan. Linda began her tenure with the former Legal Services Plan as a staff attorney, eventually becoming a managing attorney. Linda practiced in and trained other attorneys in the areas of bankruptcy, family law, tax, probate, and real estate. Linda is currently a managing attorney in the plan's Dearborn, Michigan office and handles family law cases. Welcome, Linda.
Thank you, Marty. I would like to introduce Marty Quinnan. Marty received his bachelor's degree from the University of Michigan and his law degree from Wayne State University. After a couple of years in private practice, he joined the former UAW Legal Services Plan as a staff attorney. He has practiced real estate law, family law, estate planning, probate, and tax law. Marty is now the managing attorney in the Grand Rapids office for the new plan. Okay, welcome, Marty.
Thank you, Linda.
Okay. All right, let's get started today. Marty, can you give us a list of some of the ideas that we will be talking about today?
Yes, Linda. Today we'll be talking about some things to think about and consider in a real estate transaction. Some of the things you can expect to face. There'll be a listing contract. That's a contract between the seller and the broker. We'll be talking about selling your property without a realtor, a for sale by owner transaction. Some special tips for first-time home buyers. We'll be talking about the purchase agreement and how important that document is. We'll be talking about financing options, inspections of the house, certain disclosures that may be required, title work and title insurance, property tax prorations and other closing costs that can come up, and escrows, closing documents, and the actual closing itself.
Okay, well, let's start with each one of them at once. Let's start with each one of them. The first one is a listing agreement. A listing agreement is a document used by the realtor. Is that correct? So if I am selling my house, what should I be looking for before signing a listing agreement?
Yes, first of all, the listing agreement is that special contract between the seller of the home and the real estate agent or broker that the seller hires. First of all, the agreement should be reviewed by an attorney. This is a contract, so as the seller, you're bound by the terms of the listing contract. Your plan attorney can go over that with you and make sure you understand it before you sign it. Be careful of the realtor who tries to discourage you from having an attorney review your documents before you sign them. Also, before you hire a realtor, shop around. Get some recommendations from some people that you know. Talk to neighbors if they've sold a house or have bought the house recently. How did things go with them in the transaction? Did the realtor do the work they were supposed to do? You can do some internet searching on the realtor. Google them and find out if there are negative or positive comments about them. And then it can be important to work with a realtor who knows your neighborhood, who knows what the values of homes are in your market.
Okay. Well, Marty, can you tell us some of the things that should be in a listing agreement?
There are several important items that should be set out in the agreement between you, the seller, and the broker. The first of all is the commission. That is the amount that the realtor is going to get paid. It's generally a percent of the sale price. Typically about 6% of the sale price is what the realtor gets for their commission. Another important factor is the duration of the listing contract. How long will this realtor have the exclusive right to sell your home? The listing agreement would also include the asking price. What is the price that the realtor is going to offer your property for? And you should be aware that if you get an offer for that asking price, you may be contractually bound to the realtor to accept that offer. The agreement should also have, it may also have other provisions about whether the realtor will share a commission with another real estate agent. And it also should list what the obligations of the realtor are. The realtor should advertise your home. Is he going to use legal newspapers or the multi-list service that all brokers in the county generally subscribe to? Are they going to put up signs, have open houses, or do other kinds of advertising?
Okay.
These listing contracts, another important provision of them is what is usually in these contracts is called a protection period. Now, this is a clause in the listing contract to cover sales of your home, which may happen after the listing expires. If there's a protection period in that listing contract and you sell your home to someone who saw the house or knew of it for sale during the listing contract, and you sell it during this protection period, even though the listing contract is expired, as a seller, you may still be liable for the commission. So in negotiating or drafting a listing contract, you want to, as a seller, want to make sure that you can keep that protection period as short as possible, not 6 months or more, preferably just 30 or 60 days.
Okay. All right. And as always.
Well, yes, sure. Your UAW plan attorney is happy to review this listing contract with you. And please call us before signing a listing contract.
Okay. Well, Marty, we have a few questions about listing agreements. First, I've signed my listing agreement, but what happens if I find the buyer rather than my realtor?
Well, the listing agreement should cover this, but as a rule, even if the realtor is not the one who brings the buyer to you, you are going to have to pay the commission.
Okay.
So the listing contract says the realtor has this exclusive right to sell your house during the listing contract. Now, you may have some provisions in the listing contract which accept you from paying a commission if you sell to a particular buyer. For instance, if you know someone ahead of time who might be interested in buying your house, but they're not ready to make the offer yet, you could tell your real estate agent, well, I want to accept them from this contract, so if they do make me an offer, I won't have to pay your commission.
Okay. Well, now, Marty, suppose I've signed this listing agreement and I've hired this realtor, but I really don't think this realtor is working in my best interest, and I am just totally unhappy with the realtor. Is there anything I can do?
Well, you can try to retain in the listing contract the right to terminate the agreement at any time. Most standard listing contracts don't permit this. You can't just walk away or fire your realtor, in other words. You could negotiate something with the realtor. You could try to have this put in the contract before you sign it, or you could try to negotiate some right to give them notice that you're not happy with their work and you really don't want to work with them anymore, and they may be willing to let you out.
Okay.
I found that in many cases, realtors, if you're not happy with them, then they know you're probably not going to be as cooperative as you would otherwise be in helping show the house and getting it ready for sale. So in many cases, they might be willing to let you out.
Oh, okay. Good information.
Especially if you sign with another broker.
Okay. Well, thank you. Let's go on to a new topic, for sale by owners. Now, Marty, several of our viewers have asked, what if I decide I want to save the commission and sell my house myself? Can I do that?
Yes, you can sell your home by yourself. It does require some work on your part, and you should proceed carefully and always have, as always, have your plan attorney help you with the documents.
Okay. Now, are there some things I should be aware of if I'm thinking about selling my house myself?
If you're going to sell your house by yourself, you should consider several factors. First of all, do you already have a buyer? If you have a
Yes.
buyer, then it makes sense to proceed without a broker.
Okay.
If you don't have a buyer, how much time do you have and knowledge of the market do you have to advertise and research the sale? Are you going to be available to show your home to buyers who want to come over? Are you working? Are you going to only be available on weekends or evenings? So it can be a lot of work on your part if you're trying to sell your property on your own. Are homes in your area selling quickly? One thing I'm concerned about often with people who are selling on their own is that with real estate prices these days, they are going up fairly rapidly, sometimes a couple $1,000s or more every month. So are you sure you know what the right value of your house is?
Well, Marty, now, what if I decide that I'm going to go ahead and sell the house myself without a realtor? What are some of the things I need to do?
Well, the first thing you should do is speak with your plan attorney who can give you advice on the pertinent laws and regulations in your area and warn you. Your plan attorney can also warn you against pitfalls in the transaction and answer any other questions you may have. The next thing you want to do is determine the proper selling price. And do you have a mortgage on your property? You have to pay that mortgage off before you can have a closing. So beware of that. You have to make sure you can sell your property for enough money to pay off that mortgage. Do you owe any back taxes, or do you have any other liens on the property that have to be cleared up before a closing? If you can't, then that money will be taken out of your proceeds at the closing. But you can research online. You can go to some sites like Zillow, several other sites like that, that will tell you what homes in your area have sold for in the past year or so. It's important to be realistic about setting a selling price for your home. And then you have to decide how and where you're going to market your home. How are you going to advertise it? If you live in a place where property is selling pretty quickly, you may just be able to put a sign up in the yard, and that may get you a lot of traffic. You may get a lot of buyers knocking on your door. One thing that will probably happen is that you'll get a lot of calls from realtors who say, even though you don't have a listing contract with anybody, they may knock on your door and say, I've got a buyer. I'd like to bring this buyer over. And you can, of course, invite them to come over, but remember, you're not obligated to pay their commission if they bring a buyer. In other markets, you may have to decide, if there's not a lot of traffic or a lot of activity in your neighborhood, you may have to decide that you want to advertise in some other way, posting on a website or putting ads in the newspaper or something like that.
Okay. Now, Marty, are there things that I should be careful not to do?
Yes, if you're selling on your own, or even if you're selling with a broker, there are some things you should not do. Do not make any representations about the property that could be used against you. For instance, don't make a representation like, this roof will be good for 20 years. Don't misrepresent anything about the mechanical or structural condition of the house. For instance, don't tell someone that the basement doesn't leak when in fact there may have been seepage for a while. And don't allow yourself to get pressured into moving or signing documents before you can be ready.
Okay. Well, let's move on to another topic, first-time home buyers. Let's look at things from the buyer's side for a moment. We have some viewers who are first-time buyers and would like some helpful hints as they begin the process of looking for and buying their new home. Marty, do you have some advice for them?
Yes, Linda, I do. My first bit of advice to first-time home buyers is to don't rush into anything. Make sure you've taken the time to determine where you want to live and consider all the factors that are important in buying a house. What can I afford? How much money have I saved for a down payment? If I have to start saving now, maybe I don't want to buy a house for another 3 or 4 or 5 years. I may have to start putting money aside to save for a down payment. How much can I afford in a monthly payment? What will my budget allow to make a monthly payment, which you should also include property taxes and your homeowner's insurance as part of your monthly payment. And can I qualify for a mortgage? How is my credit? Are there things that maybe I have to clear up on my credit record before I will qualify for a good mortgage? If I can't qualify a mortgage, do I have to look at other options for buying a house? Other financing options? Where do I want to live? What neighborhood do I like? Home prices can vary quite a bit from city to city and even from neighborhood to neighborhood. Are schools a consideration? And do you want to be close to your family or close to your work? Is your commute going to be a factor too?
Well, those are very important considerations. Now, Marty, are there any other things that I should consider if as a first-time buyer?
Yes, I mean, your timeline is important. How much, the more time you allow yourself to research the market and consider what your budget and your income allow you to buy, the better chances you'll have of making a good decision and finding the right house at the right price. If you're a buyer, you may want to work with a realtor to help you with the search for a home. Realtors have special expertise in all the homes that are on the market and can direct you to homes in your price range that fit the number of bedrooms or other aspects of a house that you're looking for. And remember, as a buyer, the seller is the one who pays those realtor fees, so it really doesn't cost you anything to hire a realtor as a buyer to help you look for a house. And if you make an offer, if you're a first-time buyer or any buyer, and the seller says no, they turn the offer down, don't get discouraged. You can always make a counter offer perhaps, or go on and look for another house.
Okay, the next area we want to discuss is purchase agreements. Let's say we have a buyer and we have a seller, and they're ready to make a deal. Where do they go from there?
Well, the next thing, after they've agreed on all of the terms of the deal, all of the price, the financing, the time that it's going to take to close, they enter into a purchase agreement. This is a written contract between the buyer and the seller that sets out all of the terms and conditions of the sale. Once this contract is signed, it's a binding legal document. Oral agreements are not valid for the sale of property. So you can have discussions with someone and even reach a verbal agreement to pay a certain price for property, but unless it's in writing, it's not binding on either the buyer or the seller. It's very important to have this purchase agreement reviewed before you sign it. This is the document that will contain all the terms and conditions that we'll look at later on when we get ready for a closing, to make sure that all of the expenses and costs are prorated or allocated the way the purchase agreement sets them out. So if there are disputes that come up later, we will always look back to what the purchase agreement says in resolving disputes. Your UAW, your legal service plan attorney, can draft a purchase agreement for you, or we can review an agreement if someone else has prepared one for you, and suggest any changes that might be helpful or answer any of your questions.
Okay, well, Marty, along those lines, what kind of things should be in a purchase agreement?
Well, this document has to include some specific items. The price of the property is critical. Representations regarding the condition of the property may be in the purchase agreement. Not only the price, but the method of payment. How is that price going to be paid? Is it going to be a cash deal? Is there going to be mortgage financing, or perhaps a land contract? The purchase agreement should set out the earnest money deposit, the good faith deposit that a buyer makes in signing an offer, and how other taxes and other costs are going to be paid between the buyer and seller. It's also important to have a deadline on when will financing be approved. When will closing occur? We want to have an outside deadline. We just don't want an open-ended contract that would tie your house up as a seller for a year or so. So we need a deadline on when the closing is going to occur and on when the seller is going to turn over possession if they're not going to do it at the closing. Additional items may also include personal property items that the buyer may want to keep, appliances, washer, dryer, stove, refrigerator, things like that. Or if the seller wants to retain some fixtures, perhaps wants to remove the chandelier, that should be in the written purchase agreement as an exception. The agreement would also include other conditions such as appraisals, financing approval, title issues, things like that. And also, you may find that there would be state or county authorities that would have special regulations or require special inspections, such as well inspection or a septic inspection.
Okay. Now, from the seller's point of view, what are some of the things that they should look for in the purchase agreement?
Well, you want to make sure the buyer's serious, that they want your house and that they're going to go through with the deal. One way to do this is to make sure that their earnest money deposit is large enough. You don't want just a $5 earnest money deposit, because then the buyer can walk away and he hasn't lost anything. So you want to get a large enough earnest money deposit. It would be nice if the buyer can bring you a pre-approval letter from a mortgage lender, so you know that they're qualified credit-wise to get a mortgage to buy the house. The purchase agreement should allow the seller to retain the earnest money deposit under certain conditions if the buyer defaults. And again, as I said, the purchase agreement should have time limits, deadlines for when they're going to apply for the mortgage, how long do they have to get mortgage approval, when will the title work be done, those kind of deadlines. When will the closing occur?
Okay. Now, earlier today, Marty, you told us not to make any representations about the property. Is this information dealt with in the purchase agreement?
Absolutely. This is a very important part of the purchase agreement for the seller. The purchase agreement should include language that states the property is being sold as is, that there are no warranties or representations. The buyer has inspected it and knows what they're getting, and they're buying it as is. The seller is not guaranteeing any part of the property. And if the seller thinks there are items that might need repair, that an inspection might show are a problem, the seller may want to limit the amount of repair costs that they might be liable for. And they can do that in the purchase agreement.
Okay. Now, finally, from the seller's perspective, is there anything else I need to consider?
Well, one other thing that sometimes comes up in purchase agreements is a provision that allows the seller to continue to show the house for sale until the deal closes. I see this often when the buyer makes an offer and makes it conditioned upon the sale of the buyer's house. So the buyer says, I'll buy your house, but I got to sell mine first. Well, who knows when that could happen? That may happen right away, but it may not happen for a few weeks or months. So in many cases like that, we put a clause in a purchase agreement that allows the seller to continue to list the house for sale. So if they get another offer, they can go to the first buyer and say, hey, this is my deal now. You either have to drop that contingency on the sale of your house, or I'm selling to this other person.
Okay. All right, now let's look at things from a buyer's perspective. As a buyer, what do I want to see in the purchase agreement?
Well, as I said, with the earnest money deposit for the seller, you'd want to get a high amount. As a buyer, you'd like to get away with putting a lower amount for an earnest money deposit. And make sure there's language that allows you to get that earnest money deposit refunded in case of a failed inspection or a low appraisal or some other financing condition that doesn't go through. If you need to sell as a buyer, if you have to sell your current home before you can close on the purchase of a new home, then that should obviously be a condition of your contract.
Right.
That can be written right into the contract. So if the sale of your home does fall through, you're not on the hook to buy the new house and you get your earnest money deposit back.
Okay.
And As a buyer, you'd like the seller to make representations about the condition or quality, mechanical or structural or otherwise, of the property.
Okay.
And if you're concerned that some repairs might have to be made, you may ask the buyer, or the seller rather, to make some of those repair costs. Or if the inspection shows that some of the repairs could be significant, then you may want the seller, you may want to renegotiate the purchase price. Maybe some repair cost that needs a new roof or something. That's expensive. You may want to deduct that cost and reduce the purchase price and sign an addendum to the purchase agreement.
Now, whether you are a buyer or a seller, you should call the plan attorney who will review or prepare the purchase agreement for you. Is that correct?
Absolutely. You should call the plan attorney. This is a binding contract, and you want to make sure you have one of your plan attorneys review it for you. That's why we're here.
Okay. Now, the next area is financing. As you know, purchasing property usually requires a great deal of money. I understand that there are a variety of ways to finance the purchase of real estate. Some transactions may be cash, a land contract, but most are financed through a mortgage. So let's talk about each one of them. Now, Marty, I found my dream house.
Good.
However, it also did not have a dream price. But fortunately for me, okay, I had some cash because I sold my prior house, okay. I also had a lost uncle who discovered me, and now I've inherited some money. So I would like to purchase this house by cash. Is a cash purchase possible?
Yes, a cash deal is possible. If the buyer has sufficient cash and sufficient funds to pay for the property, this can be a relatively simple transaction. If you're the seller, you obviously, if a buyer's offering cash, you may want to get some confirmation or proof of funds on deposit from a bank that the buyer has the money to pay cash, because you're taking your house off the market.
Okay.
So you want to make sure they have money there to pay for at closing. And you may, if they're selling their house and that's how they're going to pay cash for your house, you may want to see their contract. You may want to look and see what they've got to sell their house to make sure there's going to be enough money there to pay for your house. And you may want to have the buyer give you a substantial earnest money deposit to hold the deal.
Okay. Okay.
If you're the buyer in a cash deal, you want to make sure you have the property inspected. You should hire a qualified inspector for that. You should have an inspector if you're buying and getting a mortgage or land contract, but certainly in a cash situation, you want to make sure you have it inspected. You should insist on title insurance to make sure that the seller owns it free and clear, that there are no liens, property taxes have been paid, and that when that seller signs a deed, you are in fact getting clear title. So for both buyers and sellers, it's important that the appropriate documents be prepared, and your plan attorney can review these or prepare these for you.
Okay. Now, Marty, over the years, I've heard a lot about land contracts. What is a land contract and how does that work?
Well, a land contract is another way to finance the purchase of a home. Instead of borrowing money from a bank or credit union or a mortgage company, the buyer counts on the seller to help finance the transaction. The buyer makes payments over time to the seller, signs a contract with the seller that they're going to pay this much over time to buy the house. So they don't get a mortgage, they aren't paying cash, they just have an agreement with the seller to pay over time. Buyers sometimes have to use a land contract if they can't qualify for a mortgage. Maybe they have some negative marks on their credit record that they have to take a couple years to clear up. And during that time, they may qualify for a mortgage later on, but right now they may need the services of a land contract to help with that. From a seller's standpoint, land contracts can be somewhat attractive too, because generally a seller can get a much higher interest rate on the balance owing on a land contract than they could putting the money in the bank if they got cash from a closing.
Okay. Well, now, Marty, is there usually a down payment in a land contract?
Yeah, so the land contract, as a seller, you'd certainly want to make sure you got a large enough down payment. because if the buyer defaults, it can take you a while to get title back. So you want to get a large down payment on a land contract as the seller. The contract usually involves then again these payments over time, monthly payments at a fixed interest rate of some kind, and the length of the contract. Is it going to be a 10 or 15 or 30-year contract? Is it going to fully amortize over the period of the contract? Or if it's just a shorter term contract, 5 or 10 years or even less, will there be a balloon payment due? Will the buyer have to go get financing somewhere else to pay off a balloon?
Okay. Well, Marty, how is a land contract different from a mortgage?
Well, the big difference for the seller is that the seller doesn't get all their money at the closing. They have to wait over time to get paid. For the buyer doesn't get a deed. They don't get the legal title deed to the property until they pay off the contract. In a mortgage situation, the buyer does get a deed. So they are the title holders if they finance with cash or a mortgage. But in a land contract situation, the buyer does have what we call equitable title. So it does have the right to claim it as a homestead for property tax purposes. And we always record a document, often called a memorandum of land contract. We record that with the deeds office in the county to make sure that the buyer's legal interest in the property is recorded, so the seller can't sell it to someone else without a title company seeing that.
Okay.
And your plan attorney can prepare that land contract for you.
Okay, thank you. All right, now let's talk about mortgages, which is probably the most common method of financing a purchase. There are lots and lots of ads and commercials for mortgage companies out there. How do mortgages work?
Well, mortgages are institutional financing. It's a loan to the buyer from a bank or credit union or mortgage company. It's a loan which is in which the buyer signs a promissory note. Like when you're buying a car, you sign a note to make payments over time at a certain interest rate and a certain amount. And so this promissory note is signed obligating the buyer to pay back the loan company, and the buyer also signs this mortgage document, which creates the lien on the house. So the mortgage company, the mortgage lender, is secured, and they can, if there's a default, they can foreclose and get the property back.
Okay. It seems to me, Marty, that sometimes it may be tough to get a mortgage.
Lenders do have pretty stringent requirements. The buyers will have to show that they qualify financially, that they have a work record, that they've been employed for steady and regular employment for a time. They have to show that their budget allows them to afford the payments, that based on their income and their other debt ratio, that they can afford to make the required payments under the mortgage note, plus taxes and insurance every month. A buyer may have to show that they have funds on deposit with another bank that they would be needed to pay for the closing costs, for their down payment or other closing costs that they might want to make. The mortgage lenders will also run credit checks to make sure that the buyer has good credit. And the mortgage company will require generally an appraisal of the property so that they know that it's worth what the buyer's paying for it, so that they are secured. If there is a default, they're not going to lose out.
Well, Marty, do I need a large down payment to get a mortgage?
Well, mortgages do require a down payment. Can be a substantial down payment depending on the type of loan you want to get. The amounts can vary depending on whether you're getting a conventional mortgage loan. Some types of loans, VA loans or FHA loans, sometimes can be as little as under 5% down. But generally 5 to 20% down in cash is what the buyer would be required to bring to a closing. If your down payment is less than 20%, then generally the buyer will also be required to pay private mortgage insurance, or PMI, and that is paid out monthly as a monthly additional cost to your monthly mortgage payment.
Okay. Well, Marty, what happens to the balance owed after the down payment on the mortgage?
Well, the balance of the mortgage is paid off over time. under this promissory note. The most conventional loans are 30 years. You can have I've seen 15-year loans, and it varies. The term can vary. I've seen some that have even 10-year loans. Credit unions often are willing to give 10-year loans. The interest rate that you pay is set in the note, so that usually doesn't change. Sometimes if you want, you can make extra payments on your mortgage. If you want to pay it off before the 15 or 30 years is up, you can make an extra payment. And you'd be surprised. If you made a double payment on a 30-year mortgage, you'd be surprised at how much faster you would have that paid off.
Okay. Well, Marty, we have a question from a viewer. They want to know, what is the quickest way to pay off your mortgage?
Well, that would be one way, to just make extra payments.
Okay.
Just every month or so, make an extra payment. Now, you should know as a buyer that if you don't make your payments, the mortgage company can default. They can foreclose on the property, and that's a process that in many states does not even require court action. That can be done often through just publication in legal news. So the buyer has to be very careful. They can lose their house if they don't keep their payments up. As a buyer, you may also want to shop around and see what kind of mortgage loan you can qualify for. You may bring, if you can get pre-approval from a loan company, that can be attractive to a seller. If you can show a seller, I've talked to some lenders, they pre-approved me already for this amount.
Okay. So pre-approval does make you more attractive, okay?
Yes, it
does. You know
does.
that you have money in advance, okay? Our next area is inspections. So now I have a purchase agreement. My purchase agreement has been signed. I've been pre-approved by a mortgage company, and I'm ready to purchase my house. What is going to happen next?
Well, now the purchase agreement signed, we're getting ready for the process to get ready for closing. And one of the first things that will happen as a buyer, even as a seller, is the house is going to be inspected. The buyer should absolutely make sure their purchase agreement contains the provision for an inspection. The lender may also require an inspection. If an appraisal shows that the appraiser has some concerns, it's possible that the appraiser may tell the lender, why don't you send your own inspector out? But be sure as a buyer to get a qualified inspector to hire to do the inspection for you. If the inspection finds issues with the property, the buyer and seller will then have to decide how they want to proceed. If the purchase agreement contains a contingency which requires the property to pass inspection and serious defects are found, the buyer may be able to cancel the deal and get his earnest money deposit back. If the inspection issues are relatively minor, the buyer may still want to purchase the house, and the seller may agree to make some repairs before the closing to satisfy the inspection report. The parties could also agree, if the inspection finds serious problems, they could agree that they have to negotiate the price again.
Okay.
That the cost is going to be too high for some of these repairs. The seller may not want to pay for them, but the seller may say, okay, I'll reduce the price.
Okay. Now we do have a viewer who is a seller, and he wants to know, is it worthwhile to have an inspection done on a house before he even has a buyer or a purchase agreement?
Oh, as a seller?
As a seller.
Well, as a seller, I don't think it would be necessary to have an inspection done and pay for it by yourself. I mean, the inspection should be the buyer's responsibility. As a seller, you should know pretty well what the condition of the house is. And if you're working with the realtor may point some things out and may indicate that, well, you might want to fix these things up over here a little bit, or do some cosmetic work over here. But I as a seller, I probably would not hire an inspector beforehand.
All right, let's move on to the next topic, disclosures. If the seller is aware of a problem, say like a leaky basement or a wet basement, does he have an obligation to disclose this to the buyer?
Well, while there may be some variances from state to state, and generally the purchase agreements will say that a buyer is buying something as is, generally the seller cannot conceal defects that they know about, such as a wet basement or something like that. If a seller does that, then they may open themselves up to a claim, a lawsuit by the buyer. Some states require that certain disclosures be made regarding structural and mechanical condition of the property, or regarding things like septic and well features. And your state or city may require other separate disclosures too.
All right. Well, another area we're discussing is title work and insurance. Now, I know that the cost associated with buying or selling property is title insurance. It's very expensive. Now, is there really a need or necessary for us to buy title insurance? Can I just skip this process?
No, you should always get title insurance. That is something I have no problem saying to buyers or sellers. There should always be title insurance. If a buyer is getting a mortgage, a title search and title policy will be issued, and that will be required by the lender. But even if there isn't a mortgage transaction, it is still a great idea to get title insurance.
Okay. Well, does title insurance protect the seller or the buyer?
Well, the title insurance protects both, really. It is a search of the history of ownership of the property. The title search can go back years, and the title company looks for deeds and mortgages and maybe liens. Sometimes divorce cases show up or probate cases show up. So these are things the title company will look for. And they'll want to make sure that those things are all cleared up and properly transferred down the chain of title. As a seller, you're warranting that you own and are transferring good and clear title to the property. If the title search reveals any issues, these can be resolved before the closing. You don't want to wait and find out something at the last minute at the closing that there's a problem in the chain of title. And this can be a particular problem I've seen with family-owned property. Some property's been in the family for generations, and everybody assumes, well, it's heir property. Of course, mom got it. Dad owned it when he died, so mom got it. Well, that may not necessarily be the case. There may be something that has to be done in the chain of title to clear up those kinds of ownership issues.
Okay.
And as a buyer, of course, you want to make sure you're getting clear title to the property you're purchasing. Unpaid taxes or unpaid liens, income tax liens, state or federal income tax liens can show up. Those agencies record those liens with Register of Deeds offices. So those things would show up in a title search, and you want to make sure that those are all cleared up before the closing. If a title company misses something or makes a mistake in their title search, the title company generally will bear the cost of clearing up those mistakes.
Okay. Well, Marty, based upon that information, title insurance is very important to purchase. Okay. The next area is tax prorations. What exactly are tax prorations and how do they work?
Well, tax prorations basically mean the adjustment between the buyer and seller of the property taxes on the property for the year. It essentially involves, for example, the seller pays property taxes for the time of the year they've owned it, and the buyer picks up the difference for the year. As a simple example, if the annual property tax is $1,200 and the seller has owned the house for 8 months of the year, the seller should pay $800 of that,
okay.
$100 a month.
Okay.
And then the buyer would be responsible for the other $400. So the calculation of the tax proration is based on a number of factors. The most important one is, what does the purchase agreement say about it? The purchase agreements will discuss whether the proration is going to be based on a calendar year, are the taxes paid in advance or in arrears, and these are all negotiable items in a purchase agreement. What is the amount of the bill? When are they due? And as I said, it's a negotiated item. It can be a significant cost item that shows up in the closing.
Okay. All right, but it should be also in writing, correct, in the purchase agreement?
It should be in the purchase agreement,
okay.
Yes.
All right.
The method of proration, right.
Okay. Are there any other fees that need to be considered?
Yes, another fee that can come up is a special assessment. We have to be careful of these. Special assessments are charged to property by governmental units, a county or a township or a city, for major improvements, things like roadways or sidewalks or water lines or sewer lines, even drain improvements, drain clean, county drains. So these governmental units will issue a special assessment to pay for these major projects, and they can be expensive. It can be $6,000, $15,000 per parcel for each piece of property. And these governmental units know that people just don't have the money to pay up front for that. They can if they want, if they're in a special assessment district, but normally property owners want to pay that over time. And that can, if the special assessment shows up, the purchase agreement has to determine who's going to be responsible for any balance owing on a special assessment. Normally, I think the balance owing on a special assessment would be the seller's responsibility, but it is negotiable. It can be negotiated. The buyer could assume the remaining assessments. There may also be, as a type of cost to property, condominium fees or homeowners association fees, and often these are paid on a monthly or annual basis, and those can be prorated or adjusted between a buyer and seller. Your plan attorney can discuss these with you and review the contract and the closing documents and make sure that you understand what the proration method is and that the closing company did the prorations properly and fairly.
Okay. Our next area is escrow. Now, sometimes people talk about money held in escrow after a real estate transaction. What does that mean?
Well, an escrow is an arrangement where you use a third party, someone who's neither the buyer nor the seller, to hold cash to ensure that the buyer or seller meets certain conditions that have come up in the closing or in the purchase agreement. A couple of examples of escrow. One would be a repair cost. Let's say the inspection shows that repairs are needed, the roof maybe, but the repairs can't be done before the closing. The seller might agree to make those repairs or pay a certain amount of money toward them, and the escrow agreement, usually the title company would hold back some money from the closing proceeds and hold that until the repairs are made. And when the repairs are made, the title company would then release the escrow money to the seller. Another example that's pretty common is a escrow for rent. Sometimes sellers aren't ready to move out at closing. They may need 30 days or so. They may be waiting to close on the purchase of another house. So they may need some extra time. Often the purchase agreement will provide that the seller will pay rent for that time. If they need 30 days, then you may want to escrow 30 days worth of rent at the closing. If the seller moves out, then the seller moves out after 15 days, they should get half of that escrow money back. Let's say they put $1,000 down for rent escrow and they move out after 15 days, they get $500 back. The buyer would get the other $500. So an escrow is an arrangement with someone else to hold the money to ensure that some other conditions or terms are later satisfied.
Okay. All right, let's move on to the closing documents. As I understand this, closing documents consist of all the paperwork needed to sell and finance the property. Can you tell us some of the things that are included and how do we know if they are correct?
Well, you're right, Linda. There's a lot of paperwork in a closing, especially if it's a mortgage transaction. The buyers, the lenders, the borrowers, rather, the buyers may get a cramp in their hands from signing everything they have to at a mortgage closing. But these documents can be reviewed by your plan attorney. Title companies are happy to send these closing documents to us to review before the closing. Often the title company will go over them with us. They'll send them to us. We like to look at them and then call you to discuss them with you and answer any of your questions. The closing statement is part of the closing package, and that is a document which itemizes all of the costs, the charges, and the credits between the buyer and seller. How are they going to pay their costs? The title company will take the money out and pay those costs, pay for the title insurance, adjust the property tax prorations, pay any unpaid property taxes, pay off the mortgage. If the seller has a mortgage, they'll take that money right out at the closing. And all of those items would be on the closing statement that break everything down. And as the attorney, we want to make sure those numbers all add up properly. The inspection report should be part of the closing package. So if the buyer's had an inspection, that should be there, and also any disclosures that the seller may have made. The mortgage itself, the mortgage documents are there, your promissory note and other required truth in lending documents, which itemize the interest rate you're paying, how much your monthly payment's going to be, and it'll give you an idea if you paid the full term of the mortgage, maybe 30 years, how much you would actually pay over that time. And many people are shocked when they see that truth in lending disclosure, which shows how much they're paying. Obviously, we talked about title insurance. The title insurance report is part of the closing documents. And if you're the buyer, you want to make sure you have your own homeowner's insurance. Okay. Certainly, if you're getting a mortgage, your mortgage company is going to require that you bring homeowner's insurance to the closing. And if you're a land contract seller, you want to make sure that the buyer has homeowner's insurance, which lists you as an insured party. So you're protected in case there's a fire. Okay. You would get paid off instead of the land contract buyer. The deed is part of the closing package, or the land contract, the title document, and we're happy to review all of those documents for you.
Okay. Well, Marty, we've had a purchase agreement. The purchase agreement has been signed by the buyer and the seller. The buyer has received his financing. We've done inspections. All disclosures have been made. We've purchased title work and insurance. All the tax prorations have been made and calculated. Escrows have been determined. Our plan attorney has reviewed the closing documents, and now we are at, I guess, the closing. Can you tell me what happens next?
Well, you're ready to wrap everything up.
Okay.
You're going to move in, but first you've got to go to the closing. Okay. You got to go to the title company, go to the bank, wherever the closing is going to be, sign the paperwork. The seller will sign the deed at the closing, transferring ownership of the property. All these other agreements, the escrow agreements, holdover rental agreements, things, the repair agreements will all be signed at the closing. You have to decide to turn over possession. If you're giving possession at the closing, give the keys to the buyer. They may want to get into the house. Obviously, as a buyer, you may want to get those keys changed too. But there also will be a report. In most cases, the IRS wants to know about the closing, so the title company or the closing agent will send a 1099 of some kind to you at the closing. And as a buyer, you'll go over the closing statements and sign everything, and sign your mortgage documents or your land contract. You'll have your homeowner's insurance with you. Bring that to the closing. And if repairs are needed, or if the seller's staying in, make sure that those escrow funds are set aside. And again, only sign the documents after you've had them reviewed by your plan attorney.
Well, thank you, Marty. You've given us our viewers a lot of helpful information for buying and selling their home. Now, we do have some additional questions for our viewer. First, how does selling my house affect my taxes? You had mentioned earlier about a 1099 form for the seller at the closing. Can you explain that?
Well, yes. The IRS wants to know when money's changed hands. So when there's a purchase or sale of property, the IRS wants to know who got what money. And so there is generally a report, this 1099 form, sent to the IRS. If you're selling your principal residence, though, and you're single, you are exempt from paying capital gains tax on the first $250,000 profit on the sale of your home. Okay. So that's profit. That's the difference between what you paid for it and what you're selling for. If you're a married couple, then you get to exempt $500,000 in capital gains from capital gains tax. There's no capital gains tax for a married couple on $500,000 of profit.
Okay.
Now, this is not a new rule. It's been around for, boy, I bet 20 some years, but it used to be you could only do this once in your lifetime, and you had to be over age 55. And we would do some things like roll over profit into the purchase of another house. Forget about that. We don't do that anymore.
Okay.
You are exempt from capital gains tax whenever you sell your principal residence, but the IRS doesn't want to give this exemption to people who might be flippers of houses, who just buy houses to renovate them and turn them over quickly and sell them. So in addition to the money limit on the capital gains exemption, the IRS has other requirements. You must have owned the property for 2 of the 5 years before you sell it, and you must have lived in the home as your principal residence for 2 of the 5 years before you sell it. And you can't have done this exemption from capital gains anytime within the 2 years before you sell the house.
Okay. Another viewer has asked, what are some bad practices to look out for when buying and selling your home?
Well, really anybody not willing to go along with many of the things we've talked about today. And as a buyer, you want to be wary of a seller or a realtor who tries to avoid the inspection or tells you you don't need title insurance, things like that, or wants you to make a decision too quickly, things like that. And if a seller, as a seller again, you want to make sure that you've checked out your realtor, that you are comfortable with the price, that it's a good and fair price, and that the earnest money deposit you're getting from the buyer is significant enough.
Okay. Well, Marty, can you give us any guidance on selling property inherited from a trust?
Well, the first thing you want to do is make sure that you really have inherited it. Do you have good title to that property that came from the trust? Was it properly deeded over to you by the trustee? A lot of people say, well, my parents' will or my parents' trust says I'm the heir. But there are things that have to be done to make you the heir, to make that title transfer to you. And that may require a proper administration of the trust. Was that properly done? So you want a title search will tell you if you are owned free and clear as inherited property and can sell it. And it would show you whether there were any other issues in the title chain, also unpaid taxes or other liens. If you've inherited this property and you haven't lived there, then you have to be very careful about any disclosures you might make on the condition of the house. So be very careful in that case. And other than that, as a seller, you'd proceed in pretty much the same way we've talked about with other transactions.
We had another viewer ask that a person is married but separated from their spouse. Can they purchase a home without the consent or involvement of the other spouse?
Well, you can, but maybe you shouldn't. In most states, when you can buy property as a married person or single person without your spouse. However, there may be a presumption in your state that your spouse has an interest in the property. It could be considered a marital asset. And if you're separated or considering divorce and you buy property in your name only, it still may be considered a marital asset for purposes of a property settlement, even though that may not be your intention. So again, I'd suggest that if you're in that situation, you consult with your plan attorney.
Okay. Now, finally, our question is, what plan services are offered for selling your home?
Well, we've reviewed them in this presentation, but to summarize, we can prepare the documents, we can review the documents, we can explain things to you, make sure you understand all the terms and conditions of the documents, and then we can review or prepare your closing paperwork if necessary.
Okay. Well, we want to thank you for your participation today and to remind you that if you have any legal matter, please call the UAW-FCA-Ford-General Motors Legal Services Plan at 800-482-7700. And on another matter, recently, we've learned that many of you were not receiving our group emails, sending webinars announcements, or the follow-up emails sharing webinars, links, and PowerPoints. We think we have resolved our technical issues, and you should be getting the recording and PowerPoint for this webinar by the end of this week. We apologize for any inconvenience, and we thank our members who have let us know that they were not receiving our webinar emails. You can also find all of our webinars and the accompanying PowerPoints on our website at www.uawlegalservices.com. We usually post the recordings within 24 hours of the live webinar. And we are also excited to announce to you that we have a new YouTube channel, UAW Legal Services Plan, where you can also find our webinars. Go to YouTube, type UAW Legal Services Plan into the search, and you will find our webinars. We hope you will subscribe to our UAW Legal Services Plan channel. Again, as a final reminder, there is a survey. Please complete the survey. And again, thank you for your participation.
Thank you. It's been a pleasure. Thank you, Linda.
Thank you, Mark.